ask because they're not written somewhere. So we're going to miss him a lot. Him and I have been working together now for 22 years, kind of side by side. He's always kind of handled and managed the ATV program. I've always been a part of the snowmobile program, but we work on a lot of the same private landowners and trail maintenance and deal with a lot of the same general public when it comes to clubs and volunteers as well. But he's going to be missed.
Absolutely. Well, we've enjoyed working with him. We'll miss him on the commission, but we welcome you to the commission, Joe.
Thank you. Thank you. Yeah, looking forward. I mean, obviously, I'll be a couple things getting caught up and everything, but I have been reading through some of the emails and attachments. And I'm obviously familiar because we deal with it regularly with discontinued roads and the challenges that go along with those.
It's a challenge for all of us.
It's as clear as mud.
Mud on an abandoned road. So, okay, well, good afternoon, everyone. We'll get started. It's a not so great summer day, but we don't want to waste it anyway. I sent a bunch of materials out for us to take a look at for this meeting. Probably the first piece is just to think about and get back to me with any changes. The legislature asked us to take a look at the question of public easements and take a look at different types of uses that people make of public easements, what the need is for those public easements, what the impact of use of those public easements is, negative and positive. And then to the extent there are negatives, like soil erosion, pollution of ponds, whatever, ruts in the road, what are the solutions? How do we minimize it? So that's the reason we started talking about some changes to road law, perhaps, to try to enforce against damage to public easements. That's the context. So it's, we don't have to do it right now. If you have some changes that you saw right away that you want to make to that chart, great. But I tried to improve it and tried to focus on roads rather than trails, because although Joe and Brian have been concerned about trails, it's really roads that are used as trails that we have jurisdiction over. So I tried to put that in our language, recognizing their issues. So any things you spot that you think should be changed, you can say that now, or we can talk about that later. You can email me, whatever. Anything that jumps right out of the page?
Well, my husband says right up front, he wants to remind you about the constitutionality of requiring a private individual to maintain roads that are used by the public. I'm going to keep hammering on that because that is an issue. And as one of the early court cases said, I forgot whether it was Burnham versus Burnham or which one it was, even the antiquity will not save a law if it's found to be unconstitutional. I'm thinking of several years ago when the State and Local Government Committee put together a subcommittee to study this issue. And the subcommittee invited several people in to speak, and one of them was a law professor from the University of Maine. And I still remember what he said. He said, oh, the solution to this is to just let the people on these public easements form road associations. Well, my first thought is that was already allowed under the law. And if he didn't know that, how familiar with the law was he really? Because he should have known that the law already allows that and it wasn't fixing the problem. And my second thought was that he said, well, it would be like a condominium association where everybody shares in the maintenance. That solves the problem. And my thought is, no, that doesn't solve the problem, because in a condominium association, you don't have four-wheel drive trucks driving across your lawn during mud season. If it really were the same, you would be having to let the public come in and use your condominium. And he just didn't seem to get that. And that's the problem, is when you have the public using up something that a private individual is being forced to maintain, because if he doesn't maintain it, he loses access. So there are really two halves of the problem here. One is when somebody loses access, the Constitution requires that they be compensated for it. And the other half of it is that if they still have access, but only because they're maintaining it for the public, then you've got the constitutional issue again of taking of that person's private property, their gravel, their culverts, whatever they put into the road, taking it for a public use without compensating for it.
And so, yeah, that takes us down a different road than perhaps we were prepared to travel today.
I think we have to remember that's kind of at the root of this whole thing. If we could
Well,
solve that, we'd solve everything else.
It's potentially at the root of these things. There are other ways to try to resolve it. If you were to try to force municipalities to repair and maintain all public easements, I think we'd wind up seeing a lot of opposition and a fiscal note attached to this bill, and nothing will pass. So if we understand, you have that issue, and I appreciate and respect it, but if we try to resolve it in a way that causes money to be spent by municipalities on public easements required by the legislature, we're not going to get anywhere.
Yeah, and this is part of the problem. We've been trying to say, okay, how can we limit it so the towns don't have to maintain all public easements? We tried to say only public easements where the public is actually using it and it provides access to a residence, and the resident is being billed for taxes and the tax money is going someplace else in town. We put a bunch of restrictions to try to limit it. And we've also tried to give towns other options, like minimum maintenance. They don't have to maintain it to full town road standard. We understand what the situation. Towns don't want to spend money on these roads, but they're not understanding the flip side, which is that the private individuals don't want to spend money on the roads either when they're not the ones that benefit from it.
It's a quandary.
Mm-hmm. Which is why we haven't solved it in the last 50 years we've been here.
Right, and I don't know that we're going to solve that particular one. We could talk about that, but I think for today, we talked about a couple of other items. If we try to deal with the landscape as it is now, the legal landscape as it is now, and as we understand it now, we have public easements, and I believe, Roberta, you've made the statement that the majority of public easements are not maintained by towns, but by individuals. And if that's the case, and even if it's not, we want to make sure that these public easements remain in as good shape as possible. So whether it's the town of Wyndham that repairs the public easement, just to pick on Wyndham, or Roberta Manter and David Manter who repair the public easement, we want to try to make sure that although there's a public right to go over that easement, it stays in as good shape as possible. And so we were talking about how you can try to limit, and there are statutes that allow for limitations of use of roads, so that, for example, under Title 29A, state highway laws, there's Section 2395 that allows DOT put weight restrictions on, seasonal weight restrictions on trucks. And you'd asked what those weight limits are. I pulled the rule, and that generally is a cutoff of 23,000 pounds, generally. There's some particular exceptions, but generally that. And generally DOT can put those restrictions on at any time from November 15 to June 1. Notices, those nice orange posters that you see from the print shop at the beginning of the road. And there's an exemption for frozen highways. There's an exemption for certain vehicles. You can get a limited load permit from DOT to go through the road, if you're under certain circumstances. And of course, oil trucks go through. And so that's what the state law is. Municipalities can similarly, they don't have to do exactly the same thing, but they can similarly impose restrictions on gross weight, speed, operation, and equipment during periods of the year. And they can designate those ways. It isn't clear right now that municipalities can designate public easements. They can say they can designate public ways. That definition is one that we all have a little trouble with. And so it wouldn't hurt to be able to add to that in public easements, just to be darn sure they can do it. And so it's a tool that municipalities can do. The question was, what happens if someone violates it? Well, whether it's DOT or whether it's a municipal road posting, it's a traffic violation. It's punishable by a fine of not less than $250. So that's the punishment. That's the tool. And so I sent out a draft for us to think about. This is all new language that we'd add to 2395. to clarify, essentially, that this can be added, that we can, that public easement can be added to this, so that we can also regulate those at the municipal level and try to protect by posting those roads from damage. So that's one way that you can try to protect these public easements. Another way would be to, there are some other statutes right now. For example, under Title 38, under Title 17, which is the old state criminal code. 17 was moved to 17A back in the early 80s. But 17 has nuisance and crime and certain crimes relating to trespass. One is operating a motor vehicle on land of another, and so if you damage a public easement by operating a motor vehicle on that public easement, and you destroy that, you commit a Class E crime. So that's something that you can be prosecuted for. It's the lowest level of crime, but nonetheless, it is a crime that if you can persuade a district attorney that there's evidence, you can go after that person for it. So that's a route that the state has to deter damage to these. If your public easement gets damaged under Title 23, Section 3029A, there's a damage to public easement right that if you own land abutting a discontinued or abandoned road and there's a public easement in it, you can bring your own action in Superior Court for money damages, for relief and injunctive relief, so that you can prevent that person from coming back with the oversized pickup truck, the 4x4, the ATV, whatever, and damaging the road. It means that, yes, you have to go to court, you have to pay the upfront costs of an attorney. You may be awarded reasonable attorney's fees and costs if you prevail. So it's not shall, it's may. But that option is there. The court finds that Charlie was going up and down your road with the ATV and the four-wheeling and digging it up, and there's an option. You can not only ask the DA to bring charges, but you also can ask for money damages to make you whole. The problem, of course, is these are public easements. Most of them aren't maintained by the town. This stuff happens nights, weekends. People aren't home. You don't see who it is. It's tough to prove. Understood all that, but there are those two options, and if we add to it this protection that the municipality can post it during mud season, can post it when there's rain in the winter and there's a lot of hunting going on to try to prevent misuse of the roads. There's at least an additional tool for municipalities to try to protect the public easement. And the way this one is drafted, it's whether the town maintains it or not. So if it's the private landowners who maintain it or the town who maintain that public easement, the town still has a right to go post it. So does that sound like a logical next step for us to offer?
Yeah, it does, Jim. A question I have, do you think it would be too intrusive to try to get something changed in legislation that would require municipalities to require bonds for people that want to access public easements for logging operations? I'm trying to think of other reasons, construction projects. I don't know how to tie it in, but just, one of the towns I used to work for did that, and contractors had no problem providing a bond to the town when they accessed the roads. It wasn't just on public easements, it was town roads, but I'm thinking, can we do that on public easements? Or at least give the municipalities the option to do that if they don't already have it. And I did put out on the town and city manager and county managers listserv the question about how many towns have public easements and how many towns maintain or provide any level of maintenance. We talked about that at our other committee meeting, I think. And there's about 250 maybe or so on that listserv. It doesn't cover every town because not every town has a town manager. So it's probably, 3/4 of the towns in the state. I only received 3 responses. One from a little town up here in the county that has a public easement and does not provide any maintenance. And then the other 2 responses were from the town of Standish and Gray. And it amazed me the amount of public easements those 2 towns have and the amount of public easements that they maintain as a municipality. Maybe not year-round maintenance, but they're providing some level, kind of goes back to Roberta's minimal maintenance or whatever. So I'm just throwing that out there because maybe at some point we could find out a little more from the 2 of them or one of them about how that works. Is there funding separate from, or just to kind of maybe give municipalities a model to look at, if that would be helpful.
Ryan, what were the numbers approximately for Standish and Gray?
Let me pull up the email right now. Standish kind of just responded to the email. Gray actually sent me the list.
Wow.
So let me find that. I just had it.
Thank you for doing that. I've been saying it would be really useful if we could get MMA to come up with a survey for towns and see if we could get a better response on it.
I think we can, Roberta. I think we can work with MMA on that, to be honest with you. I wanted to do it myself just to kind of see what I would get. And I think if MMA sent something, though, from the right person at MMA, it probably would get responses from all the municipalities, including those that don't have a town manager. Okay. Jim, I'll find it. I don't want to hold us up, and
That's okay. I'm just interested in following that up. I'll bet Standish, Gray, and probably Wyndham, some of them have a lot of old farm roads that got discontinued when farming went under, as well as maybe even some lake roads.
So
my guess would be lake roads would be a large part of it.
I did find it, and it looks like the total amount for Gray is close to 30 miles of different public easements, different sections. And he also indicated if there was an association on those, what the name of that association was. Let me go see. He says, we only provide snow removal to all of these roads through a private contractor. So I'm not familiar enough with Gray to know if they have their own public works department besides that maintains their town roads. But it looks like all of the winter maintenance that's provided on those easements are done through a private contractor.
Good to know. I recall they do have a limited public works department, but it's probably busy enough taking care of townways and state aid roads, to be able to do this on the public easements. That's really helpful, Ryan. Thank you.
It would be interesting to try to find out too if there's anybody there, Gray, that remembers how this all came to be. Like, was it through town meeting, like, people living on the road associations putting pressure on, or what the history was, but I haven't gone that far yet.
I know there were a lot of towns back when the decision first came down, the opinion of the justices saying that it was illegal for towns to maintain private roads. MMA went around notifying towns that they had to stop doing that because there were a lot of towns that were maintaining roads for people that, maybe elderly people or farms that had been there for years, or just people that they had always plowed the road. And then MMA told them they couldn't do that anymore. And some of them just dropped people like a hot potato in the middle of winter and left them scrambling to try to find a plow contractor. And some towns said, well, we'll keep plowing until spring, but you're going to find somebody for next year. And then there were some towns that said, well, wait a minute, why don't we just call these public easements, and then we can use 3105A and say that this is an issue for fire and police protection. And they used that as a method of saying that they could continue providing this service, which they had provided for years.
And certain law firms advised their clients in communities in the greater Portland area that they could continue to do that as long as they got papers, a piece of paper signed, a release from lot owners, and could plow as far down as they got releases. And then those releases would basically say the public was able to go onto those properties, and go onto those roads. Yeah, and that's how we wound up with the Wyndham situation. So there are a few different ways around this, but I think the important part is just to make sure that there's an avenue for municipalities to be able to ensure those roads and the work that's done on them at least retain their integrity by being able to post them. And so that's the idea behind this amendment to 2395. And so the phrase "and public easements" as defined in Title 23, Sections 3021 and 3022 is added. Now, we don't have to think about this right now, but bear in mind that as a result of changes that the legislature's made at the behest of at least a couple of people on this panel, we have two different definitions of public easement as between 3021 and 3022. 3022 is when you're laying out an easement to get from an area that needs to reach a public road. And in that case, and in the case of a public easement that arises because of a statutory abandonment, the town stops spending money for 20 consecutive years or more on maintaining the road, the public easement is limited to motor vehicles as defined in the highway statute, which excludes ATVs, snowmobiles, and motorized wheelchairs, and by foot. The other public easements that traditionally have been obtained don't have that limitation. Just keep it in mind because it's really it will be unwieldy going forward to have two different definitions of public easements. It's going to be difficult for law enforcement. So we don't have to talk about that today. Just recognize that issue's out there, or that concern is out there. And it's something we might want to address down the road, so to speak. But for right now, I think the idea was to try to get this language. So is everyone okay with the idea of adding "and public easements" to this statute to ensure that municipalities can temporarily post these roads?
I'm okay with it. I don't think it's a full solution, but I think it's at least a token step in the right direction, if nothing else.
We're trying to make baby steps here. Mm-hmm. So, okay. So I think the two things I really wanted to get some closure on were the chart. So I'd ask you to take a look at that chart and see if there are any further changes that need to be made to clean that up. If there are any things that we've left off, whether it's the type of use, what the need is for that use, what the impacts might be, positive and negative, but primarily the negative ones, and then how we minimize those. What are the solutions for that? So this at least we'll submit this to the commission, explain what we did and how we got there, and with any luck, this will at least help us type. Oh, sorry for that telephone. It'll ring 4 times and then go to voicemail. Sorry. At least we'll get started on that first question with regard to public use. We have another group 2, looking at liability issues that we'll report back. And then the 3 and 4 that the legislature had said, I think we kind of pretty neatly discussed and were able to address. So that'll help us get through those 4 questions that were posed to us this year. That doesn't mean we have to stop there. We can keep going. We have up to 12 meetings this year as a commission, and we can try to tackle some of those larger issues. And Roberta, I know you've talked about this idea of a limited liability type of road, a limited
minimum maintenance road.
Yeah, and if you'd like to try to flesh that out, I don't mean to be putting any ideas down or whatever. If somebody has an idea that they'd like to bring to this group and in turn to the commission, and you want to take the laboring oar to put together a draft for us all to consider, please do. I'm not trying to squelch anything here, but I am trying to help coordinate those things where we have reached some agreement and can move that forward, try to address it. So that's why I went first on this piece. So that's,
Jim,
go ahead.
Roberta, you probably know this. Did we not talk about either New Hampshire or Vermont having those minimal maintenance roads already in their statutes?
I don't think there's anyone that close to us that has those. They tend to be more out in the Midwest. I know that New York a few years ago tried to pass a minimum maintenance law, and there are some communities that actually used it even though it didn't pass. And they tried to amend it and pass it again, and I think it again didn't pass. I think they're running into the same thing that we run into with MMA, is that towns don't want to spend anything, and right now they've got a good thing going for free, so why would they want to put in anything that's going to mean they have to spend more? But again, that's not looking at it from the landowner's point of view, because they've been spending the money. One of the things that we had proposed is that if you have something like that you give towns a choice. They don't have to keep the public easement. If they don't want to have to put any maintenance into it, let it be a private road. But then you have the issue of how to do that without taking land from one person and giving it to somebody else for their access. So the solution that's in 3026A is to make it voluntary. Then the problem is, how do you convince people that that's a good idea? I think it would take more education. I think also that needs to be made a little more flexible, so that right now, as it stands, when a town wants to discontinue a road, they're required to notify the landowners and give them a year in which to try to work out private agreements. But the two problems with that, one is that by saying that they're given a year, nothing happens for that year. And in that year, people who were willing to agree can get frustrated and walk away from it. I think if they're ready to do it, it ought to be able to go forward whenever they're ready. And it should be clear that this can happen even after the road has been discontinued with a public easement kept on it. They should still be able to go back and say, okay, we see now this isn't working. Let's come to an agreement and make this a private easement. The other big issue with it is that after the private owners on that road have gone to all the work of working out agreements, which can be a difficult process, and drawing up deeds ready to be filed saying that they grant each other shared private access, then the town still gets to vote on it. And the town can say, no, thanks for doing all that work, but no, thank you, we're going to keep the public easement. And I don't think that's right. Years ago, when we discontinued roads, we didn't keep any public easements. So I don't see what the big objection is now to telling towns that if the people on the road all want it to be private, they should be able to let it be private.
But just in balance, municipalities were given in 1965 the automatic retention of a public easement. Not just because the public easement allowed for public access over that road, but because without that public access, people like you would be landlocked.
Well, see, that's where the shared private easement comes in. If you cannot get the landowners to agree, part of what should be a motivating factor in that is that, okay, if you can't agree, it's going to remain a public easement, and you're going to have to end up maintaining it for the public as well as for your neighbors. So this is a trade-off. Which would you rather have? Would you rather have just your neighbors using the road and you can form a road association and they'll all share in the maintenance? Or would you rather keep it a public easement and none of the landowners are obligated to maintain it, but the public can use it and wear it out? Take your pick.
So back to my question though, there's no statute that you can refer to that, or in another state that I could go look at what that looks like?
I'm not aware of one,
I will come up with that for you. I know there are a few states that do it, and I can certainly come up with the New York proposed legislation.
I would just like to see. I'd like to try to figure out if we ever explored that here in Maine, where we would find a home for that in the statutes.
Yeah, there was something kind of like that, Ryan, at one point, and it was deemed to be unconstitutional.
It was in state law, or it was
It was
proposed?
in state law. It was actually enacted. That's Canton versus
Canton versus Canton.
Yep.
And that wasn't even minimum maintenance. That was saying that they basically could keep a public easement. They could keep a road that was not discontinued. It was still a public way, and the town was no longer responsible for doing any maintenance whatever. And that was found to be unconstitutional, which is why we find it so hard to figure out why a public easement is not unconstitutional, because it ends up with the same result. You have a public road that's not discontinued, and the public still gets to use it, but the town is no longer responsible for maintenance.
Well, has it ever been challenged in court, Roberta? I mean,
Yes.
Jordan versus Canton has been quoted in a couple of other cases, but unfortunately they didn't address what the difference was.
Well, Lamb versus New Sharon did, and the law court upheld it.
But they upheld it because they said that the public had no further interest in the road. They'd given up all their interest. They didn't consider the fact that because there's a public easement, the public still uses the road. I think if they had looked at that issue, they might have come to a different conclusion.
Well,
that's.
But it would be helpful perhaps to take a look at some other examples and see if there's something, and it may not be in New England, maybe outside New England, of this type of minimum maintenance road, and see if there's something that could be workable. But I think any time that you tell the towns that they have to maintain a road to a particular standard, there will be a cost associated with it. And that cost is something that will be a fiscal note and will sink the legislation. But let's take a look at it. Let's use this as our starting point. We know we have agreement on what we can ask for today, and then let's bring that to the commission and see if everyone else buys in. That can be part of a bill. That'll be the starting point, but it doesn't keep us from having other discussions and doing other research.
That's why we advocate giving the town a choice. If you don't want the expense, give it up. If you don't want to give it up, then why should you just keep it but thrust that expense off on somebody else? There is going to be an expense. The question is who's going to bear the expense and who gets to choose who's going to bear the expense. Is it right for the town to choose that the private landowner is going to bear the expense?
Well, I think the other thing is if the option for the municipality to give up the public easement means that everybody on the road is landlocked because they don't have private easements.
No, so that's why that's the default position. If they can't agree to give each other private easements, then they're going to be stuck with a public easement. That was written into what we proposed.
I would also say, on the other, putting on my old municipal hat, what you can do too with the minimal maintenance road, if that was ever law, and a town had the option to adopt it, it would be understood that if the town adopts a minimal maintenance road, now there's going to be maintenance on something that wasn't before. That might change the value of the properties that abut that minimal maintenance road, because you're now going from no maintenance to maintenance, and that may change the frontage. The assessing world would have to weigh in on that, but there is a difference between being on a private road versus a town road for tax purposes.
You're right. It could affect value of the property. It could affect value of the land. It could affect buildability of the land.
There are also some towns that I know I've been told repeatedly that there are differences in the tax assessment, but I know there are some towns where people have been told, oh, you get taxed the same. It doesn't matter what kind of road you're on.
Well, I don't think that's legal, but.
There are towns that do it.
It's not one of the boxes you check. You can get away without checking in Trio software. Let's put it that way. If you're doing assessing work.
I have checked my own, though, I will say, and my land value is less than people that live on town roads, because I live on formerly a private road, now a public easement. There is a difference. Not a lot. It's only like $50 a front foot or whatever, but you take all the frontage of all those house lots times $50, that does add quite a bit of value to the amount that isn't being taxed right now because we're not on a town way.
You just don't have as nice a road, Ryan.
Well, hey, it's my choice.
How about a situation where a town is currently maintaining a road and they want to discontinue it, which means no maintenance? If they went to minimum maintenance instead, seems like that would somewhat reduce the property value.
Right.
Save the town some money. Just
Right.
wouldn't save them as much as out and out discontinuing it, but then they'd still be getting a little more tax revenue.
And under out and out discontinuance, you're supposed to compensate the landowners if you're just totally giving it up based on.
It's a one-time payment for a loss of value of your property because you're no longer on a publicly maintained way.
Yeah.
And the problem with that is that then if the public use continues, then you have repeated destruction of that access.
Right.
And also there are some towns that will say, well, because you still have a public easement, you haven't lost access, so we're not going to compensate.
Roberta, in the public easement world, are issues really like, because I'm trying to think other ways around this too. Like, one of the issues is you have people who use the roads, the public easement roads, with vehicles. Are they more damaging, in your opinion, than, say, people who use those public easements as part of recreational trail systems? Or is it equally, is it across the board, some feel they're all bad?
We don't have any problem with people walking on them, hiking, coming in on foot to hunt. They're not really doing any damage. Snowmobiles don't really do any damage because they're riding over the snow, not over the land. ATV trails, if they're properly maintained by the ATV club, they're usually not a problem. It's when you get the road rider that comes in and uses it when the ATV club has said it's mud season. What's more of a problem is the four-wheel drive pickup truck that goes through at 2 o'clock in the morning in the height of mud season and just, leaves 2 ruts all the way down the road that end up washing out and really doing serious damage. There are also, the logging industry, I think, has stepped up and is doing a much better job of policing their own than they used to. But even if they grade a road when they're done with it, just the weight of the vehicles compresses the soil under the gravel. And there can be gravel that washes off of it that they don't necessarily replace, they just grade what's left. So that's sometimes an issue. Although, as I said, I think they're doing much better with that than they used to. I can show you some horrendous pictures from back in the 1980s.
But I think that issue, like I said earlier, I think that could be something put in law that requires bonding for logging in large construction projects during those times. But I'm wondering what the reaction would be from the municipal community, Jim, if we ever proposed a law that said if you had a public easement, that other than those 2 extremes, the ATVs and snowmobiles that are using it on approved trail systems and bonding large commercial operations or logging or whatever, construction operations, everything else in between, i.e. pickup trucks and things like that, not allowed unless you're a landowner. So I really think that's the issue. I really do. I think it's the pickups and the people that are just joyriding, not really not for a recreational trail purpose, just going out and drinking a few beers on the back 40 somewhere, whatever. That's, to me, the group that damages the roads more than anybody else.
Along that line, Roberta, I was curious if you couldn't shed how much of this is a rogue rider type problem that we're trying to solve with legislation when they're going to be the clientele that don't abide by it anyway. I know in your situation, it sounds like you've had quite a to-do with Fayette or whatever the town is, and kind of when the bubble bursts, it just continues to fester. But across the state, how many of these situations really remain unsolved that can't get resolved other than the rogue rider situation?
When you say road rider, you're talking about the four-wheel drive trucks?
Yeah, rogue.
With the
Just non-committal, non-compliant people.
Yeah, I think they're some of they cause some of the most obvious damage. Where, for example, you've got a long hill and somebody leaves ruts and then you get a hard rainstorm and it washes the whole hill down into the pond at the bottom. It's a combination between that and the insidious, just repeated use. People going in and out on a regular basis, and it just wears on a road. And every person that uses it is taking a little bit out, even if it's a teaspoonful each time, so to speak. It adds up. And if you could post it as being a private road, then you eliminate all of that.
So our legislation that Jim's proposing here would kind of curb a portion of that pretty healthily.
Well, everything is a step in the right direction. It's just frustrating when you've been at it for, when you're crawling for 50 years and now you're being told you can take baby steps.
I think that the problem with that suggestion, Ryan, is this. If the public has a right of access over that public easement as it stands now, can you say to the public, yeah, you can walk, you can hike, you can take your car, but unless you live there, you can't take a truck or an ATV or a four-wheel. You know what I mean? And it's going to be a little tough to distinguish.
Well, if you look closely at, I forget it was 3021 or 3022. I think it's 3022. It says that the public easement is for use by foot or motor vehicle. And that word "or" is kind of ambiguous. Does it mean that either one is allowed, or does it mean one or the other is allowed? Could you just say that they're for foot and not for motor vehicle?
I don't think so.
You'd have to make exceptions for the landowners, of course. But, could you say that the public use is for use by foot, or recreational uses excluding four-wheel drive pickups? I don't know how exactly you could define that.
Yeah, I think the tough part would be if it's public access and it's not by certain motor vehicles, not because of the fact of the motor vehicle, but because of who's driving it. It's okay if you live there to use a 4x4. It's not okay if you don't live there. Well, what if you're a visitor? You're otherwise allowed to visit. What if you can see the mischief that could cause? Or you're a logger and you want to just go down and do some work and you want a heavier vehicle. Maybe that's where you get the permit. And as was discussed earlier, the permit by posting a bond, and I think that's something we can do with our posting ordinances anyway. Put in that idea of the bond to allow for exceptions, so load limits, just like you get from the state, and that's something that we can work with municipalities by giving them a model road posting ordinance that would have that bond requirement built in. That's something we could do, or we could work with MMA on.
I liked your idea of including construction, because we've had a problem with that too. In one case, somebody bought a piece of property not knowing that the road was discontinued and wasn't maintained by the town, because we'd kept it in nice enough shape. They assumed it was a town maintained road. And from out of state, not knowing what the mud season conditions were, they told their construction crew that they had hired to go in and start building their house. And one of them got halfway in, hit a mud hole, sank, and after getting 3/4 of the way through the mud hole, instead of continuing and getting out of the mud hole, he backed up and went through 3/4 of the mud hole again and left it a royal mess. And we were able to get a hold of the person and call them and say, please don't do that again. And they were very apologetic and said they had no idea the road was going to be in that condition, and they would hold off until mud season was over. We had
Did they repair their mess?
Excuse me?
Did they repair the mess?
No, I think we repaired it.
But Roberta, doesn't that come down to your neighbor that also has access to the road that's building in there? That's their responsibility, just like the other people that have access to it?
It's their responsibility to repair it?
Well, it's a neighbor, right? That's building in there, just like you said, like the people that are allowed to go down there, if they're not allowing, like Jim said, the regular 4x4 pickups for the general public. Well, this person is someone that's building a place in there. That's their responsibility to maintain it.
It should be, but they were a couple of states away and we needed to be able to get in and out until they came up. So we end up fixing it so we could get through it.
That was going to be my next question, was how many of these situations are due to neighbors that don't hold their own fair share?
Yeah, that's a lot of it too. We've had another situation where, again, somebody wanted their house built during mud season and they didn't see that there was a problem because all their construction crew had 4-wheel drive pickups and they could get through. And we had a 2-wheel drive car at the time and we couldn't get through once they'd used it. They claim to have put a whole bunch of gravel into the road, and I have pictures of all their gravel trucks going by one after another, going up to their property and putting it on where their septic system is. So all their contributions of gravel didn't really help the road any.
Mm-hmm. Right. Well, I think we have some direction on what to bring to the commission for the next meeting. I think we have some thoughts about what next steps might be, and one might be helping to put together a posting ordinance with Maine Municipal so that towns have something to put on townways as well as on public easements that will have some teeth, and that also will have a reasonable carve out and a bond provision so that those that have to go through, but the road is still going to be maintained. There'll still be money in there to fix anything that should happen to that road. And their ideas with regard to minimum maintenance roads. We can do some research and see there's some draft ideas for that, and some other thoughts as to what we can do to try to minimize road damage, minimize public easement damage, and maximize its repair without causing undue hardship for the people who bought it.
One thing that does come to mind is that
Roberta, you're muted or quiet?
I shouldn't be muted. Can you hear me? Can you hear me?
Yep.
Yeah, we can hear you.
Okay.
Go ahead.
Yeah, there was a law in Massachusetts way back regarding discontinuance that said that proper signs have been posted on these roads to warn the public against entering thereon. And I know that when I was growing up in Massachusetts, there was a road near us that had such a sign posted. And it was a funny road. It split and went in two directions parallel to each other, one on each side of an aqueduct. And one side remained a public road and the other side didn't. And there were signs on that side saying, not for public use. And that side was in pretty terrible shape, as I remember. But kind of, a question that's come up in our minds repeatedly is what happened to the requirement to post roads to warn the public against entering thereon? That might not be a bad idea to have something like that.
So for public easements that are not maintained by the public,
Yeah.
or which would you post it? What would you say?
Well, whatever the road is, post it so the public knows. If it's not maintained for public use, pass at your own risk, or citing the law that says that it's a Class E crime to damage a public easement. That wouldn't be a bad idea. Give people the warning that there might be some consequences if they damage the road. By the way, this is sort of changing the subject, but I just wanted to mention that I've had a few new complaints in the last month or so, one of them being another situation where there's a quarry located on Discontinued Road, and questions of whether that's an allowable use of the road or not, and another where there is a problem with drugs, and supposedly there have been a number of arrests and I think several deaths as a result of drug abuse. So again, we talked about illicit uses of discontinued roads, and there's another prime example of it.
Well, if someone has a quarry or if someone has a forest, a logging area or whatever along a public easement, the right of public access would allow you to go on as a business person to harvest the timber or to remove the quarry materials.
The question in this case is whether or not it remains a public easement, because it's a little unclear.
As we know, that's fact specific.
But like Ryan said, if they had a bond before they mine the quarry or do whatever, that would eliminate some of that portion of that.
At least if they did that while the road was posted and the bond was a requirement. All right. Is this a good break point, or do we want to continue the discussion? I think we know we have a product to deliver to the commission for our August meeting. So I think maybe that's the most useful thing we can get out of today. But there's certainly a lot of ideas thrown out, and let's try running those down individually and see if when after the next commission meeting, if there's some ideas we want to try to pursue as a group. That sound fair?
Yeah, and I'll see if I can look up any existing minimum maintenance laws.
Great. Okay. Well, with that, thank you all for your assistance and input today. Appreciate it, and we'll see you in August at the commission meeting. Thanks. Have a great afternoon.